Yes, my name is Sogbeyi Eli. I'm the spokesman of the Rivers APC 2023 Campaign Council. Two matters came up today. One was the sitting of the Court of Appeal over the decision of Justice Eli on the 25th of October 2022, which nullified all the candidates of the APC for 2023 elections. That appeal was taken today, and the courts had adjourned for ruling on a date to be communicated to the parties. The other matter that came up today was before the same Justice Eli of Federal High Court 2, Port Harcourt. This time, there was a final judgment on a case brought by the PDP against Tonye, who is the governorship candidate of the party for next year's general elections. Well, the judge, in his wisdom, disqualified Tonye on the grounds that he is not eligible for dual citizenship and interpreted Section 28, read in conjunction with Section 182, sub 1, paragraph A of the Constitution, with respect to the judge, outside of what the law is and states, and what judicial precedents are on that matter. Tonye was born in Port Harcourt, Rivers State, Nigeria, in January 1967, so his citizenship of Nigeria by birth is not in doubt. Now, if you go to Section 182, sub 1, paragraph A of the Constitution, it makes a clear-cut demarcation on what can disqualify a candidate for governor of a Nigerian state. With your kind of permission, I'll read. It says, no person shall be qualified for election to the office of governor of a state if, subject to the provisions of Section 28 of this Constitution, he has voluntarily acquired the citizenship of a country other than Nigeria, or except in such cases as may be described by the National Assembly, he has made a declaration of allegiance to such other country. The point to note here is Section 28 of the Constitution defines and provides for dual citizenship in our country, in our Constitution. So Tonye, even though born in Port Harcourt, had applied and has since become a citizen of the United Kingdom as well. But that Section 182, sub 1A, clearly makes a provision that subject to that Section 28. So if Section 28 says you can be a dual citizen, then you cannot come under 182 to disqualify a candidate. And let's make this point clear. Citizenship of Nigeria is defined in Section 25 of the Constitution. 26 and 27 define citizenship on the basis of naturalization and registration. Now, for those two sections, 26 and 27, under 28, you'll be caught up by that rule in 182, because you're a Nigerian citizen by naturalization or by registration. When a citizen by birth is different. You are a Nigerian born as a Nigerian, whether of Nigerian parents outside the country or inside this country, you are exempted from that provision 182. But the judge, in his wisdom today, decided to interpret what is strange to our law, because this is a matter that previous courts, even higher benches, have decided upon. In 2004, the appeal court, then in a judgment read by Justice James Longen, who later became CJN, had decided in that case of William Ogebide versus Osula on the same issue. Again, in another matter in 2014, Labour Party against Ishola, that issue had been cited with approval. Other matters have come where the same issue had been determined. So we found it strange that it could handle that judgment against a candidate, and we have proceeded to commence, we have proceeded to file an appeal to challenge that decision, and I do know, as the law lives, as the law is clear, it will be set aside, and then the candidate will proceed to the elections unfettered. We know that these are shenanigans thrown at us by the opposition party, the PDP, and they're buying their time just to distract us. They have no foundation in law and cannot stand.